Alt P. Okay, so I'm going to let these folks in. So I am about to let you all in because evidently you can hear us. And attendees. Okay. I believe all the attendees are in. They're admitted. Let me just send out a message. Folks, I'm assuming that everyone is in the webinar and can hear us and can see the presentation. Can someone write? Yes, awesome. Thank you, Sujit. And in answer to your question, I will introduce my very talented and respected guest and myself, for those of you who are not, who don't know me. So welcome. This is a webinar, and we are tackling, for those of you who don't know me, I'm Carolyn Lee. I am a principal attorney at my firm, Carolyn Lee, Pllc. I do exclusively EB-5 immigration. It's an area that I've been very fortunate to be practicing in for the last 15 years or so. I started out doing business immigration. Well, I started out doing corporate transactions and moved into business immigration, and was very lucky to have found EB-5. EB-5 found me sometime around the Great Recession. That's no accident, and I've stuck with it. It's stuck with me, and that's all I do. And I am extremely pleased to be joined today by a good friend and dear colleague, somebody I respect very, very much. John Tishler from Sheppard Mullin. He's a partner there, and I'm going to yield the floor to him in just a minute to say a few words about his practice area. Today, we are going to be talking about COVID-19 impacts on EB-5 projects. And the angle we're going to explore is material change, the material change policy. And of course, we're going to get into what that policy entails, but we're talking about it today because it is of concern to us in the EB-5 space that these COVID-19 related impacts to projects may be deemed by USCIS to be material change, which could have very negative impacts on projects and their investors. So that's what we're talking about today. We're going to try to be practical and talk about best practices and documentation, as well as talk about the policy itself. And I say that more for myself than for John or our audience members. I can tend to be philosophical and critical of the policy and the legal foundation. So we're going to really try to keep it concrete and practical. So that's what it's going to be about today. And I am going to yield the floor, as I said, to John to talk a little bit about himself. John, welcome.
Thank you, Carolyn, and how appropriate. I was going to give everyone a warning that, of course, we're all sheltered from home, everybody on this call is, and I live 5 miles from the Miramar Air Station, and so occasionally jets fly overhead, and one is flying overhead right now, if you can hear that.
We can't hear it.
But fortunately, they're really fast, so they exit. The other thing that happens sheltered at home is I have a dog that likes to bark at the neighboring dogs that walk by. So that may happen too. And I think all of you probably feel my pain. But anyway, thank you for welcoming me on this webinar. I see on the list of attendees a number of my friends in the industry. I'm very happy to have the opportunity to talk to you all. For those of you who don't know me, I am a partner at Sheppard Mullin. We are a global law firm. I am a corporate and securities attorney, and I am head of our EB-5 practice at Sheppard Mullin. I've been practicing in the EB-5 area not quite as long as Carolyn and not as long as some on this call whose names I recognize, but I got into this about 2012. So I earned some of the gray hairs around my temples, you know, in the EB-5 program and watching it evolve. These days, I am spending most of my EB-5 time on governance matters. And that's been very opportunistic for me because all the time I was spending in the EB-5 practice, I was also a corporate governance attorney, routinely advising public companies and private companies on governance matters. It's just I never stopped doing that when I started spending a lot of time on EB-5. And when EB-5 evolved, and in particular when redeployment became a preeminent concern of people in the EB-5 industry, all of a sudden all the governance work that I had done outside of EB-5 became very relevant to the industry. And so it's especially, you know, this topic right here with COVID-19, this is a topic that we're discussing as a governance matter with all of our clients. I was on a board meeting yesterday with a public company discussing COVID-19 effects. And in many ways, what EB-5 participants face in this pandemic is the same thing that everybody else faces. And my governance specialty has proven to be handy. So I was really pleased to be invited to this webinar and be able to talk about this issue from the governance standpoint that I bring to this practice.
Awesome. And I really do want folks to hear from John and drawing from his experience, because I think folks have probably heard me talk about EB-5 more than once on more than one panel. So I'm going to try to keep my remarks to a minimum and really try to bring John's expertise and insights to the fore here. So I thought I would start with a quote that sort of captures what I think we're talking about here. And this is a quote from one of my heroes, Warren Buffett. "There's always trouble coming. The real question is, where are those businesses going to be in 5 to 10 years?" And I put that quote out there for a couple of reasons. One is that COVID-19 seems disastrous and awful, and it's certainly no good. But there's always going to be something that we're dealing with. And in my experience in EB-5, that has been the case. We're dealing with something, whether it's a change in policy or macroeconomic conditions, a particular project facing derailment. There's always going to be something. And here we are. And the real question is, well, what are we going to do with that? And I like this perspective that Warren Buffett takes. It's a long-term perspective. I think that clients who think this way are best positioned to handle the challenges of material change and COVID-19, because it makes them think in terms of, you know, what can I do now? What is the investment of time that is going to help me deal with this situation? And the folks who I've seen who are sort of, you know, looking more short term, you know, maybe this will go away if I ignore it. Those folks tend not to do as well, in my observation. So this is, I'm hoping that this will help folks kind of take that perspective as they analyze their projects and the effects that they may be experiencing as a result of COVID-19. So what are the effects that we're talking about on EB-5 projects? The effects that we're concerned with from an EB-5 immigration perspective are the effects to the business plan. The business plan that is on record with USCIS filings related to the project. And specifically, we're concerned with the effects of COVID-19 on job creation, and as the project is described, and as the progress of the project, the timeline of the project is described in the business plan on record. So with COVID-19, we're looking at changes, certain changes. They're going to include perhaps a delay in construction, or a delay in stabilization if it's already operational. Work stoppage if it's construction, or closure, partial or whole, if the project is operational. We might also be looking at the project at whatever stage it's in, perhaps needing to or considering pivoting to something completely different than what was described in the business plan on record. And why do we care about these impacts from a material change from an EB-5 perspective? Because EB-5 eligibility criteria are affected. The first is job creation. Is there potentially a delay in job creation, or perhaps a shortage in job creation as a result of these effects? And the way the job creation is described in the record can be prospective. If we're at the 526 filing stage or the 924 exemplar stage, it can be retrospective, looking back at the job creation that has already occurred or is supposed to have occurred. If we're looking at the 829 record, that's the petition that investors file at the end of their immigration process to tell USCIS, look, the business plan actually happened, here's how it happened, and here's the job creation that resulted from that activity. The other eligibility criterion, material change. Now this is a weird one. Job creation, that's statutory, that's in the regulations. It's a fundamental requirement of EB-5. Material change is a creature of policy, and it says the business plan has to keep trucking along. If it's derailed, if there's a change, and if that change is material, then it's got these rather arbitrary impacts on the investor's immigration, which I think a lot of you know about, and we'll talk about the policy a little bit more down the road. But that's what we're concerned about. We're concerned about, is this going to be interpreted as a derailment or a deviation of a material kind from the business plan? I'll just make a note that there is an overlap between job creation and material change, but the overlap isn't perfect. You can, job creation changes can be deemed material changes, but you can have, in theory, material change even when you have completed job creation. And you can have no material change, and you can have job creation problems. You can have a shortage or delay. So I would say there's significant and substantial overlap, but they are distinct, and you've got to analyze them in that way. There's also the eligibility requirement for regional centers, and we're assuming that we're talking about regional center projects here. There's the requirement to continue to promote economic growth, a rather nebulous regulatory requirement. And the concern is that if there's an impact on a project, even one where you've got a material change, a delay, or stoppage, could that be interpreted as a failure to promote economic growth on the part of a regional center? So these are the basket of potential concerns that we have in terms of how COVID-19 maps to the EB-5 criteria. So John, I'm going to ask you to try to map on these COVID-19 facts and effects on the commercial side of the EB-5 deals. What could happen? What are we concerned about?
Well, thanks, Carolyn. So I want to start out by saying, how you look at this depends upon where you're situated. And so we're usually seeing these questions in EB-5. I'm usually seeing these questions in EB-5 from two perspectives. Either I'm representing a developer that borrowed money from an EB-5 NCE, and now needs to look for some relief on that loan. But this developer didn't actually raise the money, doesn't have fiduciary duties to the investors. They're just a borrower. So that's a perspective that that we would help them look at. And by the way, part of the perspective that those people need is exactly the kinds of things that Carolyn just talked about. You have to understand the perspective of the other side, even if they aren't your concerns. So when you're an EB-5 borrower, even though you're not responsible to those investors, you got to realize that your lender is responsible to those investors. So what your lender is going to do or agree to do is going to be dependent on how the EB-5 program works. So we'll often advise in that situation. We will also often advise the lenders themselves, the NCEs that have lent funds. Now, they may have lent funds to their own project, in which case we have some special fiduciary concerns that we're going to cover later in this webinar. or they might be an arm's length lender to somebody else, and they just have a borrower who's not paying. So we look at these things a little bit differently depending on where we are on that spectrum. But with that said, let me just talk about many of the things that are coming up, and probably many of you have seen these things come up. So this list isn't going to be a mystery to you. Probably the first thing you've seen if you have any hospitality borrowers is they have requested forbearance. They have no revenue, right? So they're saying, hey, I'm not going to pay. Will you please give me permission not to pay? And that's just a negotiation that you have to try to get permission, not to pay, and that those negotiations can go almost an infinite number of directions, but they're being had everywhere, in EB-5, outside of EB-5. The next topic that we're hearing a lot about is force majeure. I'm not sure if that's in quotes because it's a French word and not an English word, or if because it doesn't. When we talk about force majeure, we're not really necessarily even talking about force majeure. So let me attack that a little bit, and I'd be happy to answer more questions about this. We could have a whole webinar on this, and I know you didn't sign on for a whole webinar on force majeure, so I'm going to try to be a little bit brief on this. But in COVID-19, people tend to be talking about three different things when they use the term force majeure. They're talking about pure force majeure, which is a clause in a contract. They're often talking about the legal doctrine of frustration of purpose, or they might be talking about the legal doctrine of impossibility. Any of those things can apply, and people are kind of just generally using the term force majeure for all of them. As I mentioned, force majeure is a contract clause, so there's not a lot I can say in general about it. You have to look at the contract, and you have to see what it says. I saw one study that only about 14% of contracts that have a force majeure clause include pandemic in the definition of force majeure. So if you believe that study, a majority of clauses don't. So the pandemic may not be a force majeure at all, and you have to move on. On the other hand, depending on the other language that's in the clause, maybe it is a force majeure. So that's something that you have to look at. As a contract clause, so there's some special things to watch for with force majeure. One is there a notice requirement? Does one party have to give the other party notice that a force majeure is happening? If so, you want to pay attention to that. Another thing about force majeure is sometimes it excuses performance entirely, says you just simply don't have to do what you promised to do. Other times it delays performance. So you have to look at that and says, all right, well, you were supposed to do it by April 15th, like file your taxes, but we'll give you more time because of this force majeure. So, and again, that's going to be different for every contract. You have to look at it. Last thing I'll point out as a contract clause is you have to think about mitigation. So before you just rely on a force majeure clause to say, well, I just don't have to do what I promised to do, anticipate that the other side will say, well, wait a minute, you were required to mitigate the circumstances that created the force majeure. And by the way, if you are the other side, you will want to argue that to the person claiming force majeure is, hey, you need to mitigate the circumstances. What does that mean? That's kind of all over the board. Do you have a question?
Yeah, I do. Just in listening to you speak about force majeure. So it seems like in the commercial context, we're mainly talking about the obligation to pay, especially in the lender-borrower context. And so the question is, does the borrower have a force majeure potential out on its obligation to pay? Now, some of the EB-5 loan agreements, there's a performance obligation beyond just payment, and it can be stylized as job creation. The borrower is required to create jobs, 10 jobs for every EB-5 investor. So how would that work? So could you just kind of walk me through that possible scenario?
It's a great question, and it really is going to be all over the board. As you point out, different EB-5 loan agreements have different things. Some of them have job creation covenants, and some of them don't. And even those that have job creation covenants can look vastly different. Some of them are as general as you say, you're obligated to create 10 jobs. Others that are more carefully negotiated kind of go into subcomponents of that, like, well, what does it actually mean to create the jobs? If the jobs are created based on expenditure, then oftentimes you'll see a covenant that requires expenditure. as opposed to a covenant that requires creating the jobs. At the same time, if there's operational jobs, there might be a covenant, directly tied to the hiring and maintenance of employees. But it's really going to be custom to your contract, and you'll have to look at that. In terms of
Oh, I'm sorry. Go ahead, John.
So in terms of payment, it's not uncommon to see a force majeure clause not excuse payment. So, and this is another thing where you got to look at the clause. It's not uncommon to say, notwithstanding this long clause of all the things that you're going to be excused from performance, it doesn't apply to payment. You have to pay no matter what.
Okay, right.
Some say that, some don't.
And how about, are there other doctrines other than force majeure that a borrower can avail itself of? So for example, let's say there was a covenant to spend and not such a broad one, like you've got to create the jobs. But if they can't spend because, the governor says construction is not an essential activity, then the borrower can't spend. So is there impossibility or other kinds of principles that the borrower can?
There sure is, and this is, I will tell you, I've kind of had to, by the way, my law firm, if people want to learn more about this, my law firm has some great resources that you can look on our COVID-19 resources page. Just type Sheppard Mullin COVID-19, you'll find it. There's 5 or 6 articles on this topic, and they're fantastic. I will admit that because I don't usually deal in this stuff every day, it's not often that the defense of impossibility comes up in a contract that I work on. I mean, this kind of reminds me of studying for a law school exam and having to a bar exam, which no one can take anymore, and go back and look at this. But I pulled up the New York State definition of impossibility. And that is the destruction of the means of performance by an act of God makes performance of the contract objectively impossible.
Okay.
Right. So if we look at that standard based on what you said, Carolyn, which is I'm supposed to spend money on this, but the government is telling me, I can't.
Yeah.
Well, we'd have to look at, well, what does it mean you can't? We'd have to dig into that. And that's what a court would do. It's very hard to win a case on impossibility. It's considered very narrow, but it might happen, right? It might happen. But I think a court would say, well, is it really impossible, or is it just financially impractical? And financially impractical is not the same as impossible. You won't win a financially impractical defense under impossibility. But like you said, the fact pattern you proposed, if the jobs are supposed to be created by having money spent on the job site and people are not allowed to go to the job site, I think you've got a good claim for impossibility. Now, if there is a way to mitigate that, if there's a way to do some other things that are perhaps not at the job site, like maybe you can pay, maybe you can be paying for the production of HVAC equipment that's manufactured off the job site, then I don't know, maybe it's not impossible. It's going to be very fact specific. Right.
Okay.
That's a great question. By the way, I will touch on the other doctrine here is frustration of purpose. That's the other one that somebody might, bring up. It may not be brought up specifically in the EB-5 context, but it might be brought up just, generally speaking with any commercial contract. And that one, the definition of that one is performance remains possible, so it's not impossibility, but the fundamental reason of both parties for entering into the contract has been frustrated by an unanticipated supervening circumstance, and that substantially destroys the value of performance. So those are the tests on that one. And again, that's another narrow doctrine. It's not meant to just let people out of contracts, but it is available and it might be applicable in a particular situation. I'm not seeing any questions on that, on those types of things. Again, everyone's thinking about that and whether they apply. So other things that we're just seeing that you got to think about when you have a borrower that's not paying. And I agree, Carolyn, that's normally what we're seeing here. There's a question I think that Carolyn will be for you when we get to it. But you may need to actually modify a loan agreement, and we're starting to see talk of that. I think a lot of times, a lot of companies are sort of in the forbearance stage with their loan agreements. They're not really sure how to modify it, right? I mean, how long is this going to last? I mean, typically, if you're going to modify a loan agreement, you're going to say, all right, I'll let you not pay, you know, through the end of May, but then you got to make up those payments over the next 6 months or something. I think a lot of people, when they think about negotiating that type of modification agreement, are saying, well, I have no idea if this business is going to open at the end of May or not. So why waste the brain damage of even modifying the contract? I'm not saying that's the right answer. That may be the right answer. It may not be the right answer. It really depends upon people's circumstances. You know, and then you know, got to look down the road of, all right, well, what happens if you just run out of patients, right? I mean, they're not paying, and it doesn't look like they're ever going to pay. Well, then you've got foreclosure and bankruptcy and all the remedies you need to think about there. And I think we're going to be talking about that a bit later.
Yeah, I hope so, because those are some pretty alarming scenarios for EB-5 lenders, because those are almost by definition, conceptually, they're like really big scale changes. And so lenders kind of staring down the barrel of having to, you know, potentially foreclose, you know, there's maybe a borrower is going to declare bankruptcy. Those are troubling scenarios. So I do hope we'll come back to that. Before job creation and after job creation, maybe we'll talk about, those are kind of EB-5 immigration concepts. So let's roll down there. Is that cool, John? Did we kind of cover? Okay.
Yeah.
So material change, the concerns. Well, I mean, you've heard me say this probably in lots of different contexts. I've written a lot about this since 2009, when the policy first was published under the December 2009 Neufeld memo for those immigration lawyers out there. The problem is that it's not defined. We don't know, you know, we look at a change and it's like, is this material change? Is that material change? That's a huge problem, because of the impacts of the impacts of USCIS finding that a change is material, and the impact is bad from an immigration standpoint. And the arbitrary thing here, in addition to not having a clear definition, is that the impacts really depend on, the severity of the impact depends on where the investor is in his or her immigration process. And I have a graphic on this, which I will go into, but there is this component that's really weird. It's, if you're already in conditional permanent residence as an investor, you might still have to worry about job creation, but you're really not worried about material change. Whereas another investor who's earlier on in the process, let's say the 526 is even approved, but she's not yet in conditional permanent residency, that investor is very worried, because that approved 526 can be revoked by USCIS if this change turns out to be material. It's a very weird thing about the policy, and we'll go into that graphic in a minute. Project delays typically are not good. USCIS, it's just a focus point of USCIS in its adjudication, and it can come down in requests for evidence when a 526 is pending, and it can come anytime. For longer projects, you could have a number of 526 approvals, and then at some point you might get a 526 RFE on investor number 72 that says, it looks like your project is not progressing on track. So explain the delay. And USCIS, as a matter of a trend, appears to be checking the public records more. It sometimes refers to Google Maps and satellite photos. It's availing itself of all of its tools to check these things, whether a project is on track, what the public records show about a project principles. So that is all in the air, and that could factor into a project strategy about documentation and disclosure, both to USCIS and the investors. Project derailment, that is there's no question that that would be an occasion for concern. If you know, now there is a vast stretch of gray because we don't know what changes are material. Changes that occur in the day-to-day operation of a business, probably not material, especially if it's on track with the business plan and you can point to that. Now that USCIS has said in its written policy that that is not material change if things are changing as a matter of how it's described, the project is described in the business plan. But other changes we don't know. But if we feel like a project it's off the rails from where we said it would be, from what we said it would do in the business plan, that is an occasion for concern, unless all of the investors are in conditional permanent residency. Long processing times are bad. Visa backlogs are bad because of this timeline for material change exposure. USCIS has not said, in answer to a question raised, how it will treat COVID-19 with respect to its potential impact on EB-5 projects. So we're in this material change policy space with no special reprieve or special accommodation or any modification arising from COVID-19, not yet. And I would be surprised if we see that. So in the meantime, we've got this situation here. And what I want to illustrate here is, we've got a stretch of a potential material change exposure. And it also depends. It's not like we know that if we clear a certain date, if we clear January 2022, we'll be okay. We won't have to worry about COVID-19 effects and material change because it's investor by investor. And it's also 526, it's like USCIS processing times come into play, and each individual investor's visa processing times come into play. If you have a project where you have a mix of Chinese investors who have a much longer wait time typically for their visas than your Brazilian investors in the same project, they're going to be through the process much more quickly and into conditional permanent residency much more quickly. You've got this, you've got this variance in your material change exposure period, and here's what it is. I mean, it's from the first 526 petition filing for investor one. And then you've got CPR period starting for that investor one. So that investor has gone through USCIS approval, which is the reported processing times now are between 31 and 50 months. The good news is that anecdotally, it may be shorter than that, but that's the reported processing time, which means it could take as long as 50 months to get to USCIS approval. Then you're gonna have to be in line for your visa. If it's immediately available, you'll get your visas quicker, you and your family members as investors. If there is a visa backlog for the country of the investor's origin, China, Vietnam, India, there's gonna be a wait until they can get their visas. That's visa availability. Then they can come in as conditional permanent residents under that visa, and then they've cleared the material change exposure period. So you've got that for your first investor, and then but you're not in the clear until your last investor is in conditional permanent residency. And so I think that this should give a flavor for the time period itself. You haven't cleared until your investors are in conditional permanent residency, and also the tremendous variance you can have investor by investor within the project, especially for projects of any scale where you have a number of investors, particularly from different countries of origin. So that's our EB-5 policy landscape. John, I want to come back to you. So we've got those we've got those background issues from an immigration side, from an immigration perspective. What are the legal issues for the NCE, for the EB-5 investor, for the EB-5 new commercial enterprise, with the effects that you've outlined as possibly in the works from borrowers not paying and things that I've talked about?
I'll be very happy to talk about that. I would love to, though, offer a reaction to what you just talked about with the last slide, which is a really helpful visual for everybody. And the fact that different investors have different interests based upon their timeline in immigration is very important from a corporate governance standpoint. And I will tell you that is showing up a lot in our governance engagements with clients, because what we're finding is investors and often their lawyers are a little bit confused about fiduciary duties in this situation. And people think that fiduciary duties are owed to each investor. And that's true in some sense, but it's largely false. Fiduciary duties are owed to the investor group as a whole. Now, any particular investor can assert a claim for breach of fiduciary duties, but that claim has to be based on a breach of those duties with respect to the investor group as a whole. And I don't think I've ever seen this show up anywhere in my governance practice as much as it shows up in EB-5, because the individual investors think you have a duty to me with respect to where I'm at in my visa process. So, you know, I'm still exposed to material change. So you need to do everything possible to prevent me from having a material change. And I don't care about those other people that aren't exposed to it anymore because they're not me. All right, I understand that point of view, but that's actually not the law of fiduciary duty, and that's not the way any EB-5 fund manager can look at it. They have to look at it as a whole. Now, that brings some very difficult decisions, but it's important to understand the decision-making framework. There's not a duty owed to treat every investor for his or her individual circumstances to optimize for that investor's individual circumstances. You can't, right? I mean, if that was the duty, it's impossible. Then fund managers would have to resign because they literally can't do their job. So anyway, I think that's important for people to think about in this. Now, let me address the question that you asked me. Here are the issues that I think lenders need to think about. First, you need to think about if your offering is ongoing. And the SEC has given a fair amount of guidance to public companies, which, you know, EB-5 issuers are not public companies, but nonetheless, it's the same securities laws that apply. And the SEC has said, hey, public companies, you really need to tell your investors what's going on with COVID-19. It's affecting everybody. You need to tell them what's going on. So how that applies to, you know, EB-5 is unless you did your offering documents in the last 6 weeks, your offering documents don't speak to this situation. And you're out there marketing your offering, or your agents are maybe, and we all know that offerings are being disrupted. But nonetheless, whatever is going on, people are using documents that were pre-COVID-19. And sometimes people will say to me, well, John, my documents that my PPM says on the cover page that it speaks as of December 15, 2019, and we have no duty to update. I'm like, well, that's great. It says that, but that's not the law. You do have a duty to update. You have a duty to tell investors all material information they need to know on the date that they make an investment decision. So some date that you put in your document, but we put them in our document. There's nothing wrong with putting that in your document. It's just you can't then rely on that to not update people for material information. So I think it's safe to say that most EB-5 projects have been materially impacted by COVID-19. And so you really need to strongly consider some sort of update to your offering documents to reflect that before you accept a new investment. Then, you know, if you've already raised the money and you're a lender, you need to think about the decisions you have to make with your borrower. Is that something that you can do on your own as a manager, or is that something that I either need or want investor consent to do? And so I think we're going to talk about that a little bit later here, but that's something you certainly need to always think about is before I do something that has a dramatic effect on my investors, do I have the authority to do it? So go back and check your operating agreement and check your PPM in terms of what you said you would do. And then even if I do have the authority to do it, is it still a good idea to check in with them in some fashion? That could be a vote, that could be a consultation, that could be an advisory vote. These are all things that you should think about. Those things are especially important to think about if you have a related party NCE and JCE. If you have loaned money to your own affiliate and you're making decisions there, courts are going to hold you to a higher standard than would be the case if you were making decisions on an arm's length basis. And one of the things to think about if you're faced with that, a vote is one way to deal with that, but it is certainly not always the best way to deal with that. And by the way, one of the reasons for that is what we just talked about on the last slide, which is different investors have different interests. You can't necessarily rely on a vote as a sense of direction for what's the best thing to do for the fund, because you might have investors voting their own self-interest that is, that's directly detrimental to somebody else's interest. And it's not at all clear that a majority should carry in that situation. It's not at all clear that just because of my 100 investors, 51 said screw the other 49, that doesn't mean you can just screw the other 49. It just doesn't mean that. So you have to have a more comprehensive analysis. Carolyn, did you want to ask a question?
Yeah, as a theoretical matter, would if there were a vote and 51 of the 100 investors voted to make a decision that's in their interest but contrary to the interests of the remaining 49, and the manager were to act in that in accordance with that vote, is that a defense against a claim that they lacked it, that the manager acted in breach of fiduciary duties? Or, I mean, I'm sure it's fact specific, but is there any kind of doctrine that would protect a manager if it acted pursuant to majority investor vote or whatever was required under an operating agreement?
That's a great question, Carolyn. And the short answer is that it's not as protective as people would think it would be. It has some protective value, for sure, but it is not as protective. It is not an absolute defense. The fact that I got a majority vote is not an absolute defense to a breach of fiduciary duty claim. A manager has, first of all, one way to think about this is those votes don't come out of nothing. Right? I mean, the investors don't spontaneously get together usually and deliver a vote to the manager. So the manager proposes something, says, I want investors to vote on it. Well, there are fiduciary duties associated with that proposal. So, for example, if the proposal was such that it was either completely ill-advised, and the proposal was ill-advised, and it put investors in a terrible position, then you could still be exposed for breach of fiduciary duty for proposing it. The other thing you have to think about is the vote coercive? Have you maybe put multiple things together in the same vote so that people, because they feel like they have to get number one, but in order to vote for number one, you're making them vote for 1, 2, and 3, then are 2 and 3 valid votes? They may not be. Someone can argue that vote was coercive. So there is just a more complicated analysis in terms of this. But again, I don't want to at all suggest that votes are important or protective. They are. In some cases, they're required. I mean, your operating agreement may require a vote of investors in order to materially amend the loan agreement. If that's the case, you just have to get that vote. I mean, period. If it's not the case, then you have to make a judgment call as to whether getting that vote is the best way to govern this fund, and that's a case-by-case determination. I'm so glad you asked that question, because I think there's a lot of misunderstanding about this in the EB-5 community, particularly sort of the necessity or value of votes. It's much more nuanced than people tend to think it is.
It is, and also the question of there seems to be, just my observation, this interpretive activity that goes on as to whether or not there's even a vote required, or whether in certain instances managers can proceed without a vote. There's you know, that seems to be an important consideration for managers as well.
It is, and I can tell you this is what I spend a lot of my professional time on right now. And sometimes, candidly, I mean, there is just a lot of I'd say people jump to a vote kind of too fast. And again, nothing wrong with a vote necessarily, but it's just not the one-size-fits-all solution to every problem. And in many cases, it's more of a problem. I mean, take a situation which isn't really COVID-19 related. I mean, let's say a manager has the authority to redeploy, but they don't need a vote to redeploy. And let's say, you know, name that time period for what you think is a commercially reasonable time to redeploy. Let's just say 12 months. I realize it's not defined, but let's just say people are starting to get really antsy at 12 months. And for one reason or another, and maybe it is COVID-19, you were unable to redeploy and you're at month 11, and you were just not able to do it before month 11. And you know, this 12 months is coming upon you. You have the authority to redeploy, but you say, you know what? I don't want to redeploy. I'm going to go out to my investors and I'm going to ask for an 80% vote, because maybe there's an 80% standard somewhere in the operating agreement. I'm going to ask for an 80% vote of my investors to redeploy. And then you don't get it. You get a 53% vote. And you say, all right, I'm not going to redeploy. They're all going to lose their visa because I didn't get my 80% vote. The same could even be true of a 50% vote. I mean, I used kind of an extreme example, but I would have the same type of analysis if the vote was 50-50. All right, at 11 months out, and you're not going to have another opportunity, what happens if you get 45% of the vote? You're just going to have everybody lose their visa? Now, maybe that's the right answer, but it's not obviously the right answer. So I think that managers really need to be thoughtful about when it's appropriate to use management, to use the authority they have. I mean, in some sense, it can be a breach of fiduciary duty not to use the power you have. You have the power, you're charged with the responsibility, and you could have a fiduciary duty to actually use it because you need to.
And I'll just say, you know, it's not easy, is it?
No.
You know, and I just having been doing this on the immigration side for as long as I have, there were always challenges, you know, with USCIS changing its policy, and always challenges. But it seems like in the last few years with redeployment, particularly, that it's just the soup of considerations for an NC manager seems thicker than ever.
Yeah, I think it's really no more difficult than boards of directors face in any other type of company. I think it's just new to the EB-5 community.
Yeah.
Because these were special purpose funds that, you know, just weren't really set up like they'd ever have to deal with this kind of thing. Right?
Yeah.
I mean, which I understand. I mean, it really wasn't on the roadmap for what you thought you were going to have to do as a fund.
Well, here's the reassuring thing, though, from what you said. I mean, companies and advisors have been dealing with these kinds of scenarios. So there's good advice, there is precedent, there are, you know, people who can help who are not fazed by these considerations. So that's comforting.
Yeah, thank you. Yes, it certainly is the precedent of, I mean, Delaware has, you know, if your fund is organized in Delaware, you have the benefit of hundreds, if not thousands of decisions and very smart judges thinking through these issues in other contexts. That's very helpful.
Well, here's a question that I'm going to throw at you. I don't know if you can see it, John. Somebody says corporate boards often have internal general counsels to advise. NCs often don't. Now that kind of brings us down. That's true. It brings us down to the reality of the conditions a lot of NC managers are operating with. So, do you have thoughts on that? You know,
I'm sorry, I had one of my Miramar Marine jets flying overhead. Could you repeat the question one more time?
Yes, it's in our chat box. I don't know if you can read it though. It says corporate boards often have internal general counsels to advise. Like they have this infrastructure that can kind of swoop in and help a company deal with these complex questions. NCEs though, EB-5 NCEs don't often have general counsels, internal advisory boards and teams of advisors. What are your thoughts on that?
Well, that's a great question. I mean, and I appreciate, I consider that a softball to someone that, for what I do for a living, this is what we do, right? I mean, and by the way, in my experience, only the very largest corporate boards, have an actual, their own lawyer that literally represents the board. They might have the general counsel of the whole company, kind of advising the board, and that's helpful. But even large companies will normally rely on outside counsel for their most difficult governance decisions. And I would say the types of decisions we're talking about here are the most difficult decisions that any normal entity would face. And they would normally get outside counsel. So, we're here, and plenty of other law firms are, also do governance work. One thing I will say is there is some overlap between the securities lawyers that do offering documents and the governance lawyers that advise boards, but they really are different bodies of law. So just out there in the wild of lawyers, a lot of lawyers like me do both of them because they just kind of, they can go together, but not all do. So there are a number of great EB-5 lawyers that do offering documents where their primary expertise is kind of real estate syndication. And so like they really know real estate. And that's a terrific skill set to have, but that's not necessarily a governance skill set. And so, you can just sort of think about that. In my case, like I said, it was kind of a happy accident that what I've done historically is largely corporate governance. I do a lot of mergers for public companies, and so we're constantly thinking about corporate governance, and we're constantly brought in as outside counsel to advise on those things. So I would say, in answer to the question, help is absolutely available. I've never seen a fund document that didn't allow a manager to hire advisors and have that reimbursed by the fund. Now, there may not be any money in the fund. The money might all be deployed. That's a different issue. But there's no question that as money does come back into the fund, that's a legitimate use of the funds to hire the professional advisors you need to do your job.
Yeah. Yep. All right. I got you off track.
Yeah. Well, I was just going to kind of talk about, it is part of fiduciary duties, but when you think about, by the way, I've seen this come up in governance, engagements where you have a loan agreement. The NCE has a loan agreement in default, and some investors calling up saying, "Go ahead, I want you to foreclose. I want you to foreclose." Well, it's not that easy. I mean, it's not that easy for a bank. If you think about it, banks don't run out and immediately foreclose on everyone who doesn't pay. Well, why don't they? Well, because it's not smart, right? I mean, they'd be out of business if that's how they conducted their business. It's not a smart way to conduct your business. You have to look at the situation. So one thing is you may not even have the legal ability to foreclose. I mean, just because someone didn't pay, there might be a cure period. There are these force majeure defenses, all that. So you got to look at, can you even foreclose in this situation? And then I think the more important question that I think is really significant for the majority of NCEs that have arm's length deals is, are they really in a position to foreclose? What are you going to do with this property when you get it?
Mm-hmm.
What are you going to do with a hotel today?
Mm-hmm.
In Vegas? What are you going to do that the owner of that hotel isn't doing? How are you going to handle this any better than they're handling it?
So
that's
I
a question
mean, I think we're probably getting a little afield with discussion of remedies, but so is that kind of an empty remedy? You have NCE managers. They are not professional, casino operators, and they're all you need licenses and these things. So I mean, is that so? But that's in the papers. It's a remedy on paper, but is it really not in practice?
So that's a great question. Well, and there's actually two aspects to it. I'm going to answer the aspect that you just asked me, but there's another aspect to it, which is that there are often subordination agreements. If the NCE is in a mezzanine position, it probably can't. I mean, this gets to the ability to foreclose. Normally, they've signed an agreement with the senior lender saying they won't exercise any of the remedies they have for some long period of time, or maybe never. It might be you can't exercise any remedies until the senior lender's entirely paid off. Well, that's not going to happen, right? In this situation, that's not going to happen. So I would say it is quite common in EB-5 for the NCD to actually, as a practical matter, not have any remedy at all. I'm sorry, as a legal matter, because they signed away the remedy in a subordination agreement. So that's the first aspect of it. The second aspect is the practical aspect of it, which is that really the best thing to do for your investors if you can't do anything better with the property than what the current owner is doing? And look, every lender faces this situation. This isn't unique to EB-5 funds. I mean, generally speaking, a bank is not as good at running whatever they lent the money to as the operators that run that business. So they face that every day, which is, what are we going to do better than they were doing? Now, they do foreclose sometimes. So sometimes after thinking about that, they say, we couldn't possibly do any worse than these clowns. We're going to foreclose. But they certainly don't do that automatically. They give it a lot of thought before they do it. And I think in many cases where the primary skill set of an NCE may well have been the ability to raise money from investors and understand their immigration needs, and that's an important skill set. Their primary skill set may not be at all operating or reselling the property that they invested in. And that's a relevant consideration. There's nothing wrong with a manager taking that into account, and it's nothing to be embarrassed about. I mean, it's nothing to be embarrassed about that you raised money for a casino, but you're not a casino operator. Normally, the offering documents would have had that as a risk factor, and that's the risk that people took. There's nothing wrong with it.
I mean, it seems necessary. I mean, from a layperson's perspective anyway.
Well, it'd be crazy. It'd be crazy to take a property that you can't do anything with. I mean, if you can't sell it and you can't operate it, then you have not operated and you have not acted in the interest of your investors, certainly from a financial recovery perspective. And, you know, I would guess you've also probably made their life more difficult from an immigration perspective in changing management. So it's a decision you really have to give a lot of thought to. I mean, that said, by the way, you know, you need to beat up on your borrower. You need to threaten foreclosure, right? I mean, you can't give them a free pass to do whatever they want. I mean, I can tell you every sophisticated borrower, and I've represented many of them in this situation, will go ahead and say they're not going to foreclose because they can't. Like they can't run this property any better than we can. So the borrowers will think, you know, they can only beat me up so much. They're never going to pull the trigger on this. Right. And that, you know, the negotiations are informed by that.
John, we have more material to cover. That was an awesome discussion though. I learned a lot, but I do want us to cover this. And I see questions about the immigration process, which I will get to at some point. But I do want you to cover investor communications. So can you cover that for us? I mean, what do managers need to know?
Sure. So like other things we talked about, first look at what you're required to do. So many documents say that you're required to send quarterly updates, annual updates, whatever it is that you're required to do. You know, this is not a time to say I'm too busy to do that. You know, this is the worst time to say I'm too busy to do that. This is the time to stay in communication. And I would say even better, you know, I would say the best practice would be to increase the level of communications. Typically what makes investors the most nervous is that they just haven't heard from anybody and then they assume the worst. That's human nature. Everybody does it. EB-5 investors are humans. They behave like humans. So I think stepping up the communication, I always think be honest, treat the EB-5 investors like adults, because they are. Be honest, you know, don't paint things rosier than they are. At the same time, don't paint things more pessimistic than they are. We've all been living with this for a little while. The world obviously hasn't come to an end, as long as you didn't die. And then if you did, you know, the world came to the end for you. But if you're still alive, the world hasn't come to an end. So, you know, be realistic. And I think investors really appreciate that, and it helps things down the road if they think you're being honest.
I do. I completely agree. Do they have to be formal? I mean, do they have to, like, you know, does it have to be a newsletter format with the columns? I mean, can they be informal, these communications?
So I think the answer is yes, but I would be careful of informal communications, especially if you've got a larger group. I mean, just like anything else, you know, it's one thing to say something sort of offhand and informal, you know, with two people at a coffee table. It's another thing to say it to 200 people.
Yeah.
And so you just need to be mindful of who you're speaking to and how people can take things out of context. So I just be careful. If you have a history of informal communications and everybody kind of gets that, then keep up your history. But I would say if you really have only communicated with investors infrequently since they invested, and now you need to step it up, I would make it formal. That would be my advice. But
Okay.
again, honest, and don't throw unnecessary legalese in. That's not helpful. Just like any communication, think about your audience. Just give a lot of thought to your audience. That's the ones who the words matter to.
And what do you want to say about the role of immigration consultants, the overseas consultants?
So they can be really helpful. But I will say my experience is they're not quite as helpful now as they used to be. And not because there's anything to do with the consultants. It really just has to do with the changes in the way investors think about things. So I remember when I first got into this, I mean, the widespread assumption was that if the immigration consultant was on board with whatever you were doing, the investors were going to be fine with it. They either weren't going to complain or they'd vote for it if you asked them to vote. So, the only person you needed to convince was your immigration consultant, and you could just forget about the investors. There was a certain ease in that. That made life a lot easier for NCE managers when that was true. Unfortunately, it's not true anymore. A lot of investors now distrust their immigration consultants. So having the immigration consultant on board may be no help whatsoever, because they've all started communicating on WeChat and spread rumors about their consultants that may or may not be true. And so the level of trust in the consultants has gone down. And maybe that's their fault, and maybe it's not, but it's just a fact that people have to deal with. And because of that, I think you really need to think about speaking to the investors directly. I certainly would not, but don't dismiss the immigration consultants. I think that's a big mistake. And in particular, you have to think about if you have one of the old style migration agency agreements where you got to stop paying them once the loan was repaid. A lot of the old agreements said that. Actually, the oldest agreements had no annual fees, right? You paid the agent up front and you never paid them again. Well, you can't really expect someone who's not getting paid and who last got a payment from you 5-6 years ago, to really step up and do a lot of work for you. So you need to kind of think about maybe you're going to have to pay the agent some more. Same is true as if you stop paying them when the loan was repaid. You have a right to do that under the agreement, but they also have the right to stop helping you. So you want to think about that. Because again, I think they are helpful. I believe they're not to be ignored. Unfortunately, it's not enough anymore.
That is awesome advice all around. We are not going to have time to talk about redeployment, which is fine, because while this is extremely important and very topical, and I know that folks want to hear about this, it is off topic and we're running out of time. So maybe I'll invite you on for another webinar.
I would be happy to do that. Redeployment would be a terrific webinar, particularly in this environment.
Absolutely. So I'm going to just cover really quickly the documentation on the immigration side. And a lot of it is like exactly what John's been talking about. It is very, very fact specific in terms of what the facts are and what you do with them. I think about it as an iterative process, which can be frustrating, admittedly, for some clients. I think a lot of folks want the comfort of knowing, okay, is this material change? Is this not? Do I have to worry about this? Do I not? And unfortunately, because of the nature of the beast of material change, it does require conversations and discussions and dissecting and pouring through. And so you sort of have to roll your arms up for that process. It's especially complex when you do this, which is very, very important. I call it investor mapping, which is figuring out where your investors are. If everybody is home plate, they're all conditional permanent residents, it's actually, it's a simpler analysis. than where you have investors all over the map. So that's a real critical piece of all of this. Measuring similarities versus the changes. That's a method that I use when looking at changes. You know, what are the points of similarity? It's very analytical, and what are the differences? And you kind of want to be like, you know, bald-eyed and just really look at it. And so when I interview clients about these, it can sound a little prosecutorial, but I do believe it's important because you want to get the facts so that we can present them in a way that is helpful for your investor communications for any presentation to USCIS. So this analytical process, I think, is critical. What are the reasons? That's a part of my analysis as well, which will feed into the documentation. Why is this happening? Why are these changes happening? And so this is where the doctrine of force majeure and these other doctrines that John talked about, I think, can be very, very important, regardless of whether you may ultimately prevail in court, whichever side you are. Having thought about these, having been counseled on them, and it gives you the ability to document your analysis. And I think that that is helpful. Is it always going to help you win the day? Probably not, but I think it enhances your chances of making a case to USCIS that it should not interpret these changes as material. Ultimately, the discretion rests with the agency and the examiner. And so to be able to present your reasons for departure from the business plan, and being able to back that up with analysis and these considerations, I think is only helpful, only helpful. Mitigation, same thing. What are the actions that you undertook as NCE, or if you're the developer and you're working with the NCE on documentation, what actions did you take? Did you take them early? Did you think about them? Did you consult with advisors? That's a part of this process. The documentation, I kind of look at this going backwards. You know, take it, you know, is it ripe for 829? Almost everything, something that's got to go into USCIS record with the investors. You've obviously got to be transparent. You've got to show how the job creation happened. If there were any changes, that is where that kind of reporting would need to happen. And so that's where the investor mapping feeds in as well. So you're talking about all of this in your 829 documentation. Obviously, your investors are now conditional permanent residents, so you may not be worried about, but depending on the timing, maybe you still have that issue. But you're looking at the documentation of job creation that you've got to put together, but you're also looking at where your other investors are. I'm talking about from the project's perspective. If you have investors whose 526s are pending, it's something that you've got to be thinking about in terms of how you present the narrative, the story of this project, because you've got to be thinking about, well, do I interfile? Is there an amendment? What about the 526s that were already approved? We don't have a process for dealing with those approved cases. There is no formal amendment process to report up those changes. So, but the point is, 829 documentation has to go in. So that is going to inform kind of downstream. You're thinking about what you might report up to USCIS. 924A, I'll just say that USCIS is looking at the 924As more closely and strategically, I'll say. Are they looking at every single 924A that's submitted every year by every regional center as closely as it is for some? I believe not. But if there is a reason for USCIS to cherry pick a particular regional center because it is interested in that regional center or a particular project or projects affiliated with that regional center, that 924A is going to get a lot of scrutiny. So, but that can also be a good thing. We don't have a formal process to report up these changes in the 526, especially if it's been approved, but the 924A might be the opportunity to report up these changes. And certainly the fact that that is on record, and if you can point to a record of disclosure, transparency, reporting to USCIS of these changes, that can be very beneficial. The 526 and the 924, I think that whether or not material, how to present, whether and how to present a potential material change scenario to USCIS at those earlier stages of immigration are important, and they're fact sensitive. And I think this is where that investment, that thinking ahead can have payoff. Again, you know, is it going to insulate a project from a material change finding or your investors? No, that's not a guarantee of that. But having thought about it, having been advised on it, having a theory for a response, regardless of what ultimately an NCE manager does, and recording that, having something in the file that is well crafted, that you can contemplate as being a part of a regional center audit record, I think is a good investment. So that I'm going to move on. That's just self-laudatory slide about all of my experience in this area. I was hoping that we would have more time for questions. I do want to take these questions that were posted, which goes like this. It's an immigration question. Just to clarify impacts on material changes during the immigration process. Yeah, assume jobs have been created. Okay, under two scenarios. One, conditional residency was awarded, investors okay. Two, 526 approved, but waiting. Conditional residency, investor may be in trouble. Yes, that is correct. And that's just this weird arbitrary on-off switch of the material change policy. If you're not yet in conditional residency, you're exposed. Just trying to clarify, because most projects with a mix of different statuses for the same projects, Chinese, non-Chinese investors, exactly. And that's why I put up that timeline that John also discussed. It can get soupy when you have investors that are kind of spread along that timeline. So just know that it can be soupy. Project, not plural. Okay, so we answered those questions. Do I get to check them as answered? That's satisfying. Do we have any other questions? I think we have time to take maybe one more. I think we are good. John, we went over, and I just thank you so much. I learned a lot, and it's heartening to know that there are, you know, competent, experienced counsel like you out there for my clients and others. So thank you.
Well, you're very welcome, and I learned a lot too. And for everyone's benefit, I mean, Carolyn and I have had a number of these discussions without an audience, you know, for particular client matters, and I would really encourage anybody facing these are critically important issues for your investors, assuming you're an NCE, for your investors and everything. You really should have, hopefully you have Carolyn, but if you don't have Carolyn herself, you should have somebody with Carolyn's comparable expertise, and you should have a governance lawyer who may or may not be a securities lawyer on top of it, advising on these issues. They're very important, and these things are being litigated now. I mean, I never intended to, you know, to be representing, you know, funds that are getting sued in this industry, but nonetheless, that is now a lot of what we're doing, because investors are hiring lawyers, and it's a reality of what you have to deal with, and you're much better off if you anticipated that and addressed it before the lawyers show up. You can be pretty well assured that the lawyers are going to show up if you have unhappy investors.
Yes, indeed. Yes, indeed. That's an excellent note to end on. Thank you, everyone, for joining this webinar, and we will talk to you soon.
Okay, thanks, everybody.
Thank you, John.